If oh, yeah, there we go. Interrupted my housekeeping. I was just going to let you know this is going to be recorded. Any questions at the end of the two respective talks? So we'll do my talk and then questions, and then Sue's talk and then questions for that, so it's all fresh on your mind. Could you please put them in the Q&A box rather than the chat box at the bottom of the screen? Just makes it a bit easier to keep track of everyone's questions. And if you're going to be staying till the end, please can you wait until the webinar finishes and then fill in one of our feedback forms so we can make sure that we're putting across the most useful family forums that we can for you. So welcome and thank you for coming. For those of you that weren't here earlier, I'm doing a talk on children with gender dysphoria, and Sue Hunter is here doing a talk on handing over the phone and the applicable law. So welcome to everyone. I've done some notes for my talk, and they should be in the handout that was sent to you earlier today. I'm going to sort of do a brief run through the lay of the land in respect to the recent CAS review and case law. It's a massive topic, so I'm not going to be talking about everything and puberty blockers and consent and so on. I'm just going to focus on change of name, which seems to be coming up quite a lot for practitioners in both care and private law. So I'm going to focus on that. But as an introduction, we're all seeing in our cases that the number of children with gender dysphoria is rising. And that is reflected in the statistics. And I put a quote in my handout. There's been a report recently conducted called the CAS review. It's an independent review of NHS services in respect of children with gender dysphoria. And it makes really interesting reading. It's not so much applicable to what we're doing a lot of the time, but actually in terms of the background, it's quite helpful. It shows that there's been a trend in recent years for there to be a higher level of referrals for teenage girls, much more neurodiversity and other associated issues in respect of trauma and safeguarding type concerns in respect to the gender dysphoria. And what they found was that there's a lack of agreement and a lack of open discussion about gender incongruence in childhood, whether it's something that's immutable or whether it's something that can change. And there's been a lack of knowledge and data collected around that. And there's an inadequate management of gender dysphoria treatment and how it's managed by the NHS. So it's not so much relevant to the law that we're applying, but I think it's important background for what's going on in respect of gender dysphoria for children these days. It's an interim report because there wasn't sufficient information to provide advice. I think what was hoped was there'd be some concrete guidance about puberty blockers and whether they're appropriate or not, but the CAS review didn't reach that far, but did make some suggestions about it not being a clinician lottery, so having more standardised approach to it, and also having nationwide coverage for gender dysphoria rather than the single service that they have at the Tavistock and Portman Clinic. So that's the CAS review. It makes for interesting reading, and I've included a little link to it in my note. There's also been recent consideration in the case law about puberty blockers and consent. And I've just made brief reference to the Bell and Tavistock case, which most of you will be aware of. That case considered puberty blockers for children and whether children could ever consent to puberty blockers. And the general answer was probably not, given the long-standing implications of puberty blockers. It was doubted that even 16 and 17-year-olds might be able to consent to that. It didn't address the question about parents consenting, and that's where A, B and C, D and others came in. So that specifically addressed the question of whether, if there aren't any other issues, child and parents agree, does it need to be referred to the court for a best interest decision before puberty blockers are given? And the answer was no, it's to be treated like other medical treatment. So that's the kind of lay of the land in respect to puberty blockers. It's a developing area of law, and we're still in a difficult position in respect of the way that it's being managed by the courts and by the NHS. It's not got a satisfactory, there's not a satisfactory process within the NHS to deal with it. And similarly, I think the courts are struggling because we're dealing with things on the hoof. We've got the Gender Recognition Act that applies to children as well as adults, but actually the law's struggling to catch up with what's going on the ground. But the focus of my talk today is about changing 4 names for children with gender dysphoria. So research tells us that actually if a child is able to use their chosen name, the risk of suicidal ideation and behaviours and depressive symptoms is reduced. And we know that for children with gender dysphoria, they have an increased risk of mental health issues and disproportionately compared to other children. So it's a real key issue, and it comes up both in the care context and the private law context. And I've put there that there are 2 options that we're looking at here. There's deed poll or a specific issue order. I've put a brief explanation of what a deed poll is. I think most people have a vague idea, but it's a certified document where the applicant says that they will vow to use the future name they renounce all previous names. And it's effectively a form of legal contract, albeit that it only concerns one person. Now, most agencies will accept an enrolled deed poll, so it can either be enrolled or unenrolled. There's no difference to the legal effect of it. An enrolled deed poll is enrolled with the Central Office of the High Court. So what that means is it's basically put on public record that this person has changed their name. The issue with it is it doesn't, as I say, it doesn't affect it doesn't change the effect of the deed poll. It is still equally valid in terms of changing that person's name, but certain agencies will only accept enrolled deed polls. And one of the issues that came up in the case that I would urge you all to read if this issue comes up in any of your cases, I've called it REW, but it's REW, F, C and D, and the quote is in my note. It's a 2020 case, High Court case. The issue is that there are a small number of bodies that will only accept enrolled deed polls, and one of those of relevance for children is examining boards, and also some foreign embassies as well. So that's caused a difficulty for quite a number of parents that have been trying to get their children's names changed for examinations coming up. And the REW case paints a picture of quite a number of deed poll applications being made. Examinations coming up, parents not wanting their children to be outed, and in fact for their kind of change of gender to be brought into the open by the fact that their name is different when it comes to the examinations. And so it was Master MacLeod that gave the judgment, took everyone through the regulations and highlighted that they're not really fit for purpose. There was an attempt to try and read the regulations in accordance with Article 8 rights, Article 14 rights against discrimination, and Section 22 of the Gender Recognition Act, which actually makes it a criminal offence to out someone, to reveal the fact that they've had a gender transition. So there is an attempt there to try and make the regulations fit the scenario, but the reality is it's a patchwork of regulations, the civil procedure rules, and case law that applies with the deed poll. I've tried to, at the foot of my note, put a helpful table because it took me long enough to try and work out what the actual applicable law was. So you'll see from that table that I've tried to break it down to children under 16, children over 16, and the various provisions that apply, and I'll take you all through that shortly. But there was a note of caution sounded by the judge in REW about enrolled deed polls for children when there's been gender dysphoria, and the reason for the changing of the name is a change of gender. So there's also been concern expressed about the Gender Recognition Act as well. So the procedure is going to be that only surnames should be published, court documents to be marked as private, and then permission to be sought in the event that there is any further inquiry to be made in respect of the deed poll application, that application to be made to the court, and the court to bear in mind the reasons why this is that they're trying to make it a more closed process in order to protect the privacy rights of the children involved. It was also made clear that where the application was based on welfare issues, that should be first dealt with by the family court, referring it for a specific issue order application, rather than going through the deed poll process, because that judgment sets up very clearly the limitations of the deed poll process. It doesn't require any views and any of the wishes and feelings of the child to be considered, which is pretty relevant given we're looking at 15-year-olds in some cases, as was the case in REW. It doesn't involve any holistic welfare type analysis. It doesn't even tell the court who has PR for the child, because there's only a requirement for the parents to self-certify that they are making the application with the consent of all of those with PR. But there isn't actually a provision for there's not, it doesn't have to be a birth certificate that's filed with the application. It can actually be a passport. And so the court isn't always kept in the loop about who has PR, what attempts have been made to try and get consent from those with PR. And so deed poll has its issues, but also it can be a very straightforward process when you're looking at both parents agreeing or the child themselves agreeing, and they're over 16, they can execute their own deed. So that's something to bear in mind. The next option is a specific issue order. And we're lacking case law in respect of change of names for gender reassignment. I've not been able to find any cases on point particularly, but I think those of you that come across change of name generally will be aware of the trend in the case law to move away from the previous suggestion that forenames aren't so important and actually it's only surnames that matter. The trend is more now towards considering a forename to be incredibly important. And I've listed some of the quotes from the relevant cases there. It is a highly personal thing to have a forename. It's what you're known about, it's what you're known for. And as Lady Justice King noted in REC, the 21st century, it's our forenames that get used much more than our surnames, and actually it is a significant issue. Article 8 is also applicable on any application to change name under specific issue order, or indeed by way of deed poll. And I've put the case law there that sets out the relevance. And then we also have the Children Act, and that's the law that the court's going to be applying on application of the specific issue order. So we've got the paramountcy principle and the welfare checklist. And I've put there the particularly relevant factors for children with gender dysphoria. So child's commitment, child's wishes and feelings dependent on age and understanding, and that plays into their commitment and consistency in their new gender. So if this is a child that has socially transitioned, is effectively out and is using that new name and presenting as a different gender, that's going to be a very forceful argument for making the order. Equally, if this is a very new decision, if it's not quite tested, if there's ambivalence from the child, then that's going to be relevant. And I've put provision for what sort of evidence you might be looking at. So maybe something from CAMS or the Gender Identity Development Service, even other health professionals in the school in relation to social transition. All of that's going to be relevant, and the court might want to take that into account on a specific issue order application. The next point is emotional harm. That's a pretty relevant factor. I quoted earlier about the use of the child's chosen name being a protective factor against mental health issues for gender dysphoria children with gender dysphoria. And I think that's certainly something that the court's going to be considering. There's also the potential emotional harm of the child effectively being pressured by another parent into gender incongruence. And I've quoted the Re-J case, which you might all be aware of, back in 2016, where the court found there was significant harm caused by the mother in that case. So this kind of takes me neatly on to the table at the foot of my notes. I've tried to make it as accessible as possible, but it's a bit of a dry area of law, so I'm not going to spend very much time on it. I've put in the relevant provisions, what the application needs to cover, what the order needs to cover, or the deed poll needs to cover. So, for example, the limiting the publication to surname only and so on, everything that was provided for in Re-W. One of the key things that came out of Re-W was if there are any welfare issues, such as in that case, it was C and D of the Re-W case were children where it wasn't gender dysphoria, it was a standard change of name because the father had been convicted of sexual assault on the children. So said the mother, there wasn't actually any evidence provided. The court concluded in situations like that, in situations where there's been a very long gap in contact with another parent, where there might be DNA tests questioning paternity, where it's been difficult to locate a PR holder, those sort of scenarios are the cases where it needs to go to a specific issue order first. And in that case, the court did actually refer it back to the parents and say, I'm not making a decision on this deed poll until the court has made a best interest decision on a specific issue order application. So I'm not going to go through the table in any more detail. I've also included the provisions where there's a care order in place as well, because that's slightly different. It's just limited to forenames, not surnames, but hopefully that will assist you all if you're ever having to deal with this labyrinth of law, and hopefully it'll provide you a bit of a guidepost along the way. So that's the end of my talk, and I think I will ask everyone to put any questions in the Q&A now, if that's okay. I'm happy to answer any you have, or if not, we'll just move straight on to Sue. I'll give it like a minute or so, just in case anyone's typing. It's always the way in these things. You talk to a blank screen and then you don't get any questions. It's almost like there's no one there. Fine, we've left it a minute. I think we'll move on to Sue. Thanks, everyone.
Thanks, Asha. That was a great talk. I think the reason there weren't any questions was because it's such a difficult and dense topic that we've got a lot to take on board. People probably think of their questions at 3 o'clock tomorrow morning, so good luck with that, Asha. I'm going to talk about handing over the phone. It's very, very common now that orders are made in relation to the phone. In the old days, it used to be a sort of, you know, the old-fashioned brick phones where you went to the provider and you got the 10,000-page printout and a number of boxes. And there was never any question that those documents were documents and disclosable. But smartphones, in my view, I suggest, complicate matters considerably. So what I'm going to talk about, it's a bit of a canter really, because what I thought would be helpful for us all to, I think we need to sort of arm ourselves perhaps a bit better, because if you've got my notes, you'll see I refer to the fact that I think the judges, there's been a sort of creeping habit where the judges are just ambushing people and fancying a canter through their phones, and are very suspicious of them because their parents in a care case, for instance. Applies just as much to private law, I might add. That there's this practice being developed, which I consider to be unfair, and it's certainly contrary to the rules, which may amount to the same thing. They're also incredibly difficult to appeal because they're case management orders, and it's very difficult to pick your moment when you should appeal that sort of behaviour by a judge, and that is very tricky as well. So that's why I thought we'd just go and have a look at the background rules about disclosure, because being sensible people, we tend to compress those rules and just proceed on the basis everyone knows what the rules are, and we'll skip the bits that we don't really need. So as you'll see from the notes, which I will hopefully follow through faithfully in the order they're on the bit of paper or your screen, disclosure, first of all, because disclosure is the reason given for making parents hand their phones over. So I thought we'd have a look. Disclosure concerns documentary evidence. And as we all know, they can be made against people who aren't a party. But I've put it in here because there may be clients who don't actually own the handset that the court is seeking to confiscate. You may not know that if you're representing them, but it's just worth having in mind that it may not be in that person's gift to make that decision about control of the phone. The family procedure rules do not provide a formal procedure for disclosure. So the common law applies, which sounds pretty daunting, but actually what the courts say about this particular area of disclosure is that, we'll get to it in a minute, that the civil law, and I'm talking about legislation, typically encapsulates the previous common law, and therefore you can skip straight to the Act rather than needing to go back to, you know, the 1400s for some assistance. Family Procedure Rules 10, and I'm looking at Rule 4.1, that provides the general powers of management. The court can make such orders for disclosure and inspection as it thinks fit. I just mentioned there for care cases, you can go to Part 12, but generally speaking, the principle is the same. The court can make the orders, but there is no specific formal procedure provided. Where disclosure is not prescribed under the rules, there is nonetheless a duty. And when I say not prescribed under the rules, having just said there aren't any, there are in fact one or two, as you know. For instance, if you're filling in a court form and it requires you to produce a document, then you have to produce it. So, you know, that's what I was referring to there. So if disclosure is not prescribed, you've still got a duty, and we all know this, the judges say it all the time, cards on the table, full disclosure, even if it's against your case, etc. So generally speaking, we start looking at this on the basis that you've got to disclose everything. And hilariously, under the Family Procedure Rules 10, it doesn't even have to be relevant, but no, don't dwell on that. Basically, you only have to disclose it if it's relevant. I think I can safely say that. Part 21 is where we go to look for the rules. And we see the interpretation. A party discloses a document by stating it exists or has existed. That's the first thing we tend to forget when we're talking about disclosure. Is it's not about showing anyone a document, it's about telling them that you've got it. Secondly, inspection of a document occurs when a party is permitted to inspect a document disclosed. So that's, for those of you who also do or have done civil law, you probably can still remember the old process of disclosure, inspection, you know, discovery by list, etc. We don't do it normally in children law because we don't need to, because first of all, typically there's very little material in pre-existing documents apart from records, i.e. hospital records, things like that. In matrimonial finance, obviously, for me has its own rules, and this talk is not about finance, but I merely make the obvious point that, of course, there are lots of more rules there, and that's because they have a lot of documents that are very significant in the evidence. I've added, for your delectation, orders for disclosure against a person who is not a party. We all know that you can do that, but I've put it there for completeness because we just mustn't forget. As I say, I think some parties certainly, we've just forgotten the rules of disclosure, and that makes it much more difficult for us to defend the sort of applications that I'm talking about. I say applications, they're pretty loose, like show us the phone. So I've put that there, but I'm not proposing to read it all out to you. There's then PD 21A, which relates to disclosure and inspection. And you'll see from 1.1, same as we've just looked at, discloses a document by saying exists or had exist. Inspection is when someone's permitted to inspect it. In family proceedings, a document means anything in which information of any description is recorded, and any copy of a document which contains a modification, obliteration, or other marking or feature shall be treated as a separate document. So what that means is you have to disclose both. So the amended version and the original version, and they're counted as two documents. Again, except in certain cases, that's not as relevant as it might be in, say, a contract dispute. But nonetheless, we need to keep ourselves aware of it. If we find ourselves ending up in an argument about a disclosure, all of a sudden we're going to need to have a slightly firmer grip on what the court or the other side are entitled to do or not do. Excuse me. We then move on to 2.1, and that provides for, other than a financial remedy proceedings, where the court orders disclosure, it will normally be for disclosure by each party setting out a list or questionnaire, the documents material to the proceedings. Well, of course, we don't do that because everybody tends to know what they mean by disclosure. And as I say, we've got in the habit of not really grappling with the question of disclosure when it comes to lay parties, because a lot of it, the statements are incredibly important, but they don't normally exhibit much in the way of documentary evidence. And well, that applies to public and private, but I was going to go on and say in private law, of course, most of the documents, disclosure mostly relates to professionals involved in the lives of the family. Anyway, the normal order will be for disclosure by each party setting out a list or questionnaire, the documents material to the proceedings, of the existence of which that party is aware and which are or have been in that party's control. You all remember, this is, these rules have been around for donkey's years, and you probably all have to answer questions about them in your exams. But it's important to remind ourselves that it's documents that either are or have been in that party's control, because that might become relevant when you're trying to run an argument about whether something on your client's phone remains in their control. Moving on. I'll skip paragraph 2.2 because it relates to financial remedies, and I'll skip 2.3 because that's matrimonial and civil partnership proceedings. Going to 2.4, which is family proceedings, the court may order specific disclosure. Disclose documents or classes of documents, carry out a search to the extent it's stated, disclose any documents located as a result of that search. Now, it seems to me that if you represent a parent, that you may find yourself in a situation where you take instructions about what is disclosable that they've got on their phone. And of course, 10 years ago, it would have been almost nothing. And now it's my whole life, including all sorts of confidential documents. So there is, one will meet or be making, depending which team you're on, submissions that a search should be carried out. And of course, it's quite difficult to carry out a search for phone. You can go and get your screen grab, your bits of WhatsApp and so on, but there are various potentially disclosable documents on your phone that aren't accessible necessarily to your client, although they have been in their control. E.g., I'm not sure Snapchat exists anymore, but anyway, there are various apps that don't, where the text of the document itself, the trace of the document, remains on your semiconductor, but the document itself can't be read. So you may be needing to look at that paragraph when you are deciding with your client what from inside their phone needs to be disclosed, and how you're going to do your search, because it may be that your client themselves will require an order or permission to interrogate their phone, certainly if they want someone else to share the cost, because otherwise they're going to have to interrogate themselves and then disclose the documents. Excuse me, sorry. So I then move on in paragraph 8 to look at the definition of document, because of course all this disclosure is about documents. It's not about toys. It's not about the thing that could have caused the injury to the child, the baby bouncer out of which it fell, and so on. So, but that, of course, is what is contained typically in your telephone. We're talking about documents. So it's defined, as I've suggested in family procedure rules, It's also in the Civil Procedure Rules, Part 31. And Mr. Justice Moylan said in Immerman, and that was a case about money, you probably all remember it, but he encouraged those in family proceedings to use the CPR, Civil Procedure Rules, in order to provide a process by which disclosure could be A, structured, I suppose, and B, enforced. He didn't say either of those two things, but I'm just pulling out a quick summary. And there is reference in the CPR to the duty to make a reasonable search for documents, and again, limited to documents which are or have been in your control. So what we are told to do in Immerman, and although it's a finance case, I have little doubt that it would be applied to the first case about a telephone that comes up in the children jurisdiction, is to go to the Civil Procedure Rules where the Family Procedure Rules don't provide a process. So I then go on to talk about smartphones contain documents which are disclosable. Smartphones, those with an academic interest in the difference between a smartphone and a computer can send me a chat question later. The difference, it doesn't really matter, because what we're talking about with disclosure is what documents are in that phone. So whether it's a computer or a phone doesn't matter too much, but it really only applies to smartphones because they're the ones that have got this huge amounts of information either contained within them or accessible. So there has been an issue, I have heard, I won't name names, but a particular judge made a finding that a handheld smartphone was a document. I can understand the arguments for that, and we'll come to what the arguments are either way in a bit. My feeling is that a phone isn't a document because, let's say it's got a letter from your solicitor on it. Isn't that a document in itself? And therefore, once you're talking about documents within documents, the whole thing gets a little bit cumbersome. However, I can well understand judges wanting to call it a document because it does simplify matters procedurally quite considerably. But as long as there's still an argument, it's up to us folks to be making it. So I go straight on in paragraph 10 to talk about failure to disclose. And the reason for that is that behind requests for phone logs or requests to hand over a handheld device or whatever, is usually a suspicion that full disclosure has not been made by the user of that handset. And any such suspicion is either supported by evidence or it's a fishing trip. But that's really, skipping all the detail, that's really what the courts are talking about when they ask to see somebody's phone. So that's why I talk about failure to disclose. It's not usually called that, but here we go. The part 20 of the FPR, you all know all these things already, but I thought I'd set them out because it's kind of areas that I was exploring to see how we could equip ourselves either to lawfully demand someone hand their phone over or to stand our ground and refuse and put the other side to a successful application or an application. So part 20 is that this provides for interim orders, and of course handing over the phone orders, disclosure orders are interim, typically, might be exceptions. So what we see there, so the FPR is simply picking up the existing statutory or other law, and in Rule 20, it makes provision for interim orders for detention, custody, preservation of relevant property, authorising a person to enter any land or building for the purposes of carrying out that order. You can spend hours looking at some of these, but land or building includes property. Includes a car. Relevant property means property the subject of an application or as to which any question may arise on an application. So we're not talking necessarily about documents here. So we may not be talking about disclosure. So I just raise that point. But we move on to Immerman, where, of course, as we know, it was about documents, and it was said removal of documents or the freezing of electronic documents, because of course it's a type of injunctive relief that they were seeking, should only be permitted by order of the High Court and under its supervision. 20A61 sets out the procedure. It's really strict, the procedure. So this is a potentially handing over a handset or going into someone's house to get it, or a combination of the two. These are very draconian orders. Interestingly, it includes a provision that solicitors must be given passwords. 7.1 deals with delivery up orders where they're likely to be executed at the premises. So quite a bit of this is about going onto people's property. But of course, if you make an order, an application to the court for an order that, whatever it might be, that you want their phone or whatever, the chances are you are going to need a search order to go with it. Because unless you make an ex parte order without notice to the person sitting in the back who's got their phone in their pocket, which is what I have seen and heard is happening, then you are going to have to apply to the judge and go down the proper route, in which case, whether it's ex parte or inter parte, the chances are you'll need to couple it up with a search order. Anyway, you will be doing this under the Civil Procedure Act, Section 7, which I go on to over the page. And that just sets out the provisions about search orders, which us old folks call Anton Pillar orders. You can make the application, you can do it without notice, it permits entry onto property, and it can only be made by the High Court. And it requires notice to be given unless you can do an ex parte. And of course, with a phone, there is always the risk that someone will delete material off the phone, lose the phone altogether, or has happened recently, and I'm sure we were all watching it, absolutely gripped, inadvertently dropped into the North Sea. And you need an affidavit in support. I've just mentioned Rybak and Langvarn, sorry, Akhmedov and Akhmedov underneath, because both of those cases involved High Court judges saying that computers should be handed over and making effectively search and seize orders for those devices. And in both cases, because they weren't satisfied, in a nutshell, they weren't satisfied that full and proper disclosure had been afforded, and this was the solution. I mentioned those two cases because they're about computers, and I think there's a very strong argument that a smartphone is a computer. It's kind of obviously a computer, isn't it? It may not be a very powerful one, but it's a computer. Anyway, I then mentioned disclosure, police disclosure, because of course, if the police have wide-ranging search powers, unlike the rest of us. So they can help themselves to as many phones as they want, and they'll track where people have gone, and they'll interrogate the phones, etc. And subject to their own rules, it is relatively easy for them to do that if it's potentially evidence in the case. In many cases that we do, both private and public, if something really serious has happened, then you will be able to get the interrogation documents from the police, i.e. they send it off and anything that comes back is a document. So that gets around the problem. But because of course, once they're out of the telephone, they are a document then, and all issues about devices and so on disappears. So I've then gone on at paragraph 30, maybe rather late in the talk, to talk about when issues arise, but I'm sure you're all following closely at the back. So issues with phones arise where there's suspicion the phone user hasn't made full disclosure. So if we're going to sort of grasp the nettle, I suppose, about what on earth do we do about these telephones, because I don't think we've all really got our heads around it properly yet, is that you will need to talk to your client about whether there is anything on their phone that they need to disclose. Now, in the old days, it was extremely rare that you would be having a conversation with a client about the content of their phone, apart from the old brick phone, you know, printed out disclosure. So we tend not to really think about disclosure in any formal sense, apart from records, hospital records and so on, police evidence. We tend not to think about it in terms of the lay parties in a case. But actually, what we should be doing, I suspect, is checking with our clients in order for them to disclose what is relevant on their phone, whether it's for them or against them. And of course, in the old days, people would have just said all sorts of horrible things about somebody else, or had their highly sexual conversations with their partner, or indeed their denied lover, etc. They'd have done it on the phone, and that's not disclosable. So we're suddenly in a very not brave new world where our clients they're sitting on this time bomb that's full of all these documents that we are not in the habit of thinking about. So I suggest that at an early stage, it is a good idea to have that conversation with the client, because we do need to know what's on there, because we may need to counter an application. I say an application, give us the phone. We may need to be countering that, or indeed making such an application ourselves. So I think we haven't quite caught up with the fact that what used to be casual conversations in the pub or on the phone are now recorded on people's telephones. Of course, they can do a lot of their own. They can go and get some screen prints, and the usual time you'll find your client or the other side or somebody disclosing a screen print is because it's in their interest to do so. What you won't have seen is the other side disclosing that same screen print, despite the fact it's against their interests, because we are not disclosing by list, we're not having inspection, discovery, however you want to call it. So the formality of the process means that we've all slightly lost track, I suspect, of keeping a proper discipline on the contents of these devices that our clients now almost universally carry. So I mentioned that they can print off documents and so on. Interrogation is relevant where they can't get the document back because it's gone, but it was there and they saw it and they know it's there. So that's a tricky situation. You would argue, wouldn't you, if you were on the receiving end, you would argue that those documents are no longer in their possession and control. So they may be subject to disclosure, so they should be on the disclosure list. I know this all sounds incredibly old-fashioned. It should be on the disclosure list, but it wouldn't be subject to inspection. That's a sort of formal way of putting it. So I then go on to say, if a smartphone is a document, because I know that certainly, well, a judge I know has been saying, well, it's obviously a document. Because if you go back to Practice Direction 21A, you'll see when you look at it that it refers to something which information is recorded in, and a telephone has information recorded in it. So the argument is it's a document. But I think there's another argument you can make counter to that, which we'll come to in a minute. That same person would say that it goes against common sense to say that only the tiny little bit of your semiconductor that's got that tiny bit of code on it is actually the document. That's nuts. And just like a cassette tape or a DVD back in the old days, or a memory stick, whatever it might be, the whole thing must be a document. And one can see the point. They also then go on to say that a professional interrogator can be instructed not to access any other information that is exempt from disclosure, i.e. irrelevant, confidential, the usual stuff. The slight problem with that is that there is wide mistrust of those who have smartphones, really about anybody who looks at it. And the fact that there'll be some person in a room somewhere whose job is to be a professional telephone interrogator, and they live an extremely exciting life interrogating telephones, is unlikely to reassure them that the video they don't want to tell you about, but is in fact a video of them masturbating, that they'd slightly prefer not to run the risk that this person in this small room doesn't just think, oh, I'll just have a look through those videos that say sex on them. So it's incredibly personal and confidential. A huge quantity of the material held on those phones. And certainly if, according to some of my clients, the fact that a professional interrogator is going to be told which bits they can look at provides relatively small amount of reassurance that actually secretly those documents won't be accessed without their permission. Then there's the argument that the smartphone is not a document, because you say, well, it contains a number of documents, like a filing cabinet or a library. And of course, what you'll be told back in exchange, or what I'd say to you, is, well, that could also be true of a cassette tape or a video or a photograph or a set of photographs, or indeed a CD, for example. So it's a difficult argument, but I think there are arguments in both ways. We would say, if we were opposing disclosure, that the document is only the bit of the chip where the information is held. Now, that doesn't mean you don't disclose it, because if it's disclosable, you've got to disclose it. But what it does mean is that you don't have to hand over your whole device, although you would, I would suggest, have to come up with a means by which that document can be accessed and then disclosed. So the difficulty is, it's not about whether you've got documents in your smartphone. Of course you have. Let's assume that those documents are disclosable. How do you get them out without compromising your other information? First of all, you make voluntary disclosure of them, of course. But if somebody comes back to you and says, we don't think you've done enough, and I've got good evidence that X, Y, or Z will be revealed by an interrogation of your phone, what you're really then trying to do is control the process, isn't it? So you say, right, well, I will get interrogated because that covers my confidentiality, and I will then decide what I'm going to disclose to you under the rules. So, these are just thoughts about how you might go about it. The difficulty is you want everyone in the case to pay for the interrogation, of course. Anyway, there's the little arguments for arguing it's not a document and therefore not disclosable as a whole, the whole device. If the court finds it's a document, you've got all the usual defences to disclosing anything else. It'll contain confidential documents. Now, normally, you wouldn't have to argue in a children case that no one should see your bank statements. But of course, if the phone device is a document and the document is disclosable, then your bank statements, the judge has just found to be disclosable. So there's huge issues, not to mention the sex videos and so on, which I'm sure all your telephones are absolutely stuffed with. Menstrual trackers, it's not that taboo these days, but you wouldn't necessarily wanting the judge seeing it. And particularly, we know just recent issues about abortion that menstrual trackers can be used for more than one purpose. The other thing I'd say about this is I've put personal correspondence. I think I should have emphasised more. What about the third parties? How many times is your phone disclosed in circumstances where confidential information belonging to third parties is completely unprotected, and their consent is not sought before that telephone is accessed? And you've got, again, the interrogator being told to block names out, or the police officer, but they do see the names. And also, it's not a guaranteed process because they don't know how to prevent jigsaw identification. So they might just take a name or a number, just block it out. But that doesn't mean that anybody else looking at that document can't work out who it is. So that's another argument to be deployed, I would say. Many people, I had a case where the judge, I can't even bear to talk about it, it was so bad. But the result of this was that despite my squeaking up and down and demanding orders and all sorts of things, the judge took the client's phone in court, and my client then didn't eat. My client was on oath, so I couldn't speak to her. My client then didn't eat. She was staying in a local hotel because she came from up north. She then couldn't eat until we were back at court the next day because her phone was her cash. So outrageous. That's why I put my hand up to do this talk, actually. That really got me going. That can be met if they're provided with another device. But nonetheless, it can go on your list of reasons why one shouldn't disclose it. So look, I've put a conclusion here. There's a good argument against defining a smartphone as a document. So that's the answer to the question I posed. Is resistance futile? No, it's not. Resistance should be far more common than it is. And we're all very willing, in my view, to hand our clients' phones over without necessarily going through the discipline of thinking about disclosure and whether we really have to. If it's alleged proper disclosure has not been made, they have to produce evidence. There's a proper process for this. It's a highly draconian order. There's all sorts of confidential stuff in there. And it is like going into your house, picking your computer up, and walking out with it, I would say. And applications need to be made in the High Court. That's the other point. So there you are. That's my talk. I think the law hasn't really quite caught up with the reality of our situation, because, as I say, documents are just used to be relatively uncommon in Children Act proceedings, and now they've got telephones absolutely stuffed full of videos and chats and all sorts of posts, rude posts on Facebook. There's all sorts of stuff there. So that was just a flavour, really, because I've become increasingly anxious about what appears to me to be a relatively Wild West attitude, where phones are handed over sometimes, I think, without due consideration of proper process and the draconian nature of what the individual user of that phone is handing over. Huge amount of personal information. So there you are. That's all we've got time for, folks. If you've got any questions, do put them on the Q&A. It was only a quick canter, and again, you'll probably suddenly think up your question at 3 o'clock tomorrow morning, in which case, obviously, just ring me straight away.
Thank you, Sue. That was a great talk, especially the point about third-party disclosure. You don't think about these things. There's a lot to think about, and you're right. I think we need to start grappling with it a bit more on behalf of our clients. So I think not any actual questions in the chat. I was just having a quick scan through. We'll end the webinar there, and if you could fill in the feedback form at the end, everyone, that would be really, really helpful. Thank you so much, everyone, for coming and for listening to two quite complicated topics that we've tried to cram into an hour. I hope it's been useful. And yeah, thank you. Thank you all for coming.
Thanks very much, everybody.
All the best. Take care.
Enjoy.